into your rebuttal time. So whenever you're ready, James Anthony Ingram versus the state of Florida.
May it please the court, counsel. My name is Robert Pierce. I'm here on behalf of James Ingram. I request 5 minutes of rebuttal time.
Okay.
Good afternoon. Thank you all very much for your time. As I said, I'm here on behalf of Mr. Ingram, who appeals the denial of his motion to suppress, which was based on the sufficiency of an affidavit supplying probable cause and, as argued by appellee, the good faith exception to the general warrant requirement. Now, there's a few points that I wanted to make about the sufficiency of the affidavit, if only because I think it'll inform so much of that conversation about good faith. The first point is that the informant in this case is not a citizen informant. This is not something that was contested directly by appellee in the answer, but the distinction will be important later. So we don't have an honest, disinterested citizen coming forward to report a crime. What we have instead is an informant who was captured after escaping prison, who was offering...
So I agree with you that you have a good argument for lack of probable cause, that the issuing judge issued the warrant incorrectly.
Yes, Your Honor. And
that the trial judge who was reviewing it at the suppression hearing analyzed the issue incorrectly. I mean, I agree with your analysis. The problem I have is your leap to, I mean, to the good faith exception. I mean, that's what the good faith exception is intended for. I mean, that a law enforcement officer can rely on an independent magistrate's review. So I'm having a hard time. There's no bad faith alleged or any of those things. It's just a bad call on a probable cause issue, and that Leon seems to suggest that there's no exclusion under those circumstances.
Yes, Your Honor. Well, Leon, of course, was contemplating whether or not there was a deterrent effect of excluding all of this evidence. However, Leon also did carve out that exception. One of those 4 exceptions was anticipating there would be a case where it would be objectively unreasonable, that the affidavit and the probable cause would be so lacking in any indicia of reliability that it couldn't be relied on in good faith. So the argument here today is that it fails under a number of circumstances, but it fails so clearly that it also fails under good faith. And the points that I wanted to make with regard to the fact that he's a citizen informant kind of lead into that.
There's nothing misleading in the affidavit, correct? The officer didn't mislead the court.
No, Your Honor. I don't believe there's anything misleading.
He put down everything. It seemed like. I mean, I read it.
Yes, Your Honor. Well, little as it was, he did put down everything.
Yeah.
The problem
about Mr. Reed, he identified who he was. He was an escaped prisoner, and the whole what Mr. Reed had said, and the whole work.
Yes, Your Honor. The problem, of course, is that we only have the statement of this informant whose reliability cannot be presumed, and in fact is actually quite questionable. So the reason that I was pointing out the citizen informant issue is because under Irizarry, the same kind of principle applies, where you have someone who's not a citizen informant and their information is being used in an affidavit, you have to have, this court acknowledged in State v. Irizarry, that you have to have other information corroborating that informant's reliability, and where you don't, you can't consider any of the information. So right out of the gate, this trips over that.
Let me ask you this, just in thinking that through, how do you corroborate a detailed explanation of a crime that's about to happen tomorrow?
Yes, Your Honor.
When the only, preparatory tools and things like that might be in a residence that you can't get to, but it's not like a tip about an ongoing crime where you can go to the residence and stake it out and look and see what's happening. I mean, I'm curious as to what you think law enforcement could have done given the time frame and the nature of the information that they were given.
Yes, Your Honor. I think that's an excellent question. There was actually a couple things they could have done. The first is that the informant has a few predictions. There are things that it makes that you can then go corroborate. The one that jumps out is the fact that he was going to rob allegedly going to rob this particular branch, because this particular branch had been robbed successfully before by someone named Trish. Well, calling that particular branch and seeing if they had been robbed would be a way to corroborate that information. He had just escaped from prison. It's unlikely that he would have come across that information by happenstance. Maybe he did, but maybe he didn't. That would at least go to his reliability. The other thing is apparently he approached 2 other individuals who both declined to be a part of this exercise, but he did approach them. Well, you could ask the informant who those individuals were. The moment you have a second corroborating informant saying that, yes, this individual is planning a bank robbery, there's your probable cause. That gets you into the house. But more than that, if you're worried about this bank robbery, which they should be, it's a dangerous allegation. If you're worried about that, there are other methods they could have done. They could have waited to see if his behavior tracked that was predicted by the informant. So if the informant was saying he's going to leave tomorrow and he's going to be dressed a certain way and he's going to be carrying this, possibly toy pistol and he's going on his way to a bank, if he leaves his house and is dressed that way and goes to get in his car, that might arise to reasonable suspicion. And if you're worried that it doesn't, the moment that he starts getting closer to that bank, I think that's game over. That is reasonable suspicion that criminal activity is afoot, and you can then stop him there. And he would have the gun on him, and you can effect the arrest and charge him with conspiracy to commit bank robbery, which was the original goal for the search warrant. So I think there was plenty of options available to corroborate this information. The problem is it just wasn't done. We only have the word of this informant, whose reliability is not presumed, whose reliability is in question, whose reliability isn't as good as the informant in Gates. And because of that, you can't get over that bar. The fact that there isn't any corroboration, that it's only the statement, that no work was done, that's what makes this.
How do you address the sort of just common sense question that sort of arises, at least in my mind, that, okay, your argument is that the affidavit so lacked an indicia of probable cause that a police officer untrained in the law should have just recognized immediately there was no probable cause, when not only did the issuing magistrate find probable cause, but the reviewing judge thought it was there too. Mm-hmm. Did a legal analysis, a trained lawyer, judge, I mean, it just is a common sense matter to say that it's so lacking that the untrained law enforcement officer should have caught it when
Right.
two judges.
Well, the language that we have in Leon is whether or not the reliance on that affidavit is objectively reasonable, whether it's so lacking in any indicia of probable cause that its reliance would be unreasonable. And I think we have that here. We only have the statement of someone they're making a statement after they're being apprehended. We don't have the kind of situation where they're exposing themselves to criminal sanction because they're lying to police. He's already facing that and staring down the barrel of a consecutive sentence because he just fled prison.
So when the police officer was going to execute the warrant that's been reviewed by two judges and approved by two judges, the officer should have said, you know what, those two judges, they're wrong, and I really can't execute this because it is so objectively unreasonable or lacking an indicia of probable cause, I just can't go forward?
I think the objectively reasonable police officer would find that the probable cause in here was not, that there wasn't a sufficient amount of information in order to make a probable cause determination. I don't even think it's close, because we don't have anything other than this statement, someone who just got caught, who has every incentive to lie, who's telling a sufficiently fanciful tale, but that's all it is. They didn't find any of this stuff. It wasn't there. It never happened. So I reserve the remainder of my time for rebuttal.
May it please the court, my name's Rebecca McWiggin, and I'm here on behalf of the state. At this point, two different judges have reviewed the corners of the affidavit and found that the totality of circumstances supported probable cause. Based on that, the warrant was valid. Alternatively, even assuming both judges got it wrong, the good faith exception would apply because the four circumstances where it doesn't aren't here. So unless this court has any questions, then
What's your argument that there was probable cause?
The argument for probable cause, well, there's not corroboration. There's other ways to support the veracity of the statement. Here we have the face-to-face interview by not one but two different officers that could judge the credibility of what the man was saying to him. He gave explicit and detailed a description of who, what, when, where, why, and how the crime was going to be committed, with the sole exception of the specific time of day wasn't alleged. It was based on his firsthand knowledge because the defendant was trying to involve him into this conspiracy, and he was also staying at his house, which is how he had the firsthand knowledge. And they said he wasn't trying to exculpate himself from the crime because he knew that it wasn't going to help him anyway. Based on the totality of those circumstances, they had probable cause to believe the veracity of the statements. And again, if they didn't, the good faith exception applies, and we'd ask that you affirm.
Okay, thank you.
Thank you.
Just a few points to contend with what Appellee said. The first thing, the statement that was made in this affidavit that, he's not offering this out of any, self-interest, was made in the passive voice. This was something I pointed out in the brief, but because we don't know who the author of that statement is, it's really kind of worthless. We don't know who to attribute it to. The second part of it, that in Gates, they say that the magistrate's determination as to probable cause shouldn't be the mere ratification of the bare conclusions of others. There wasn't any information put forth as to why he would think that, so that conclusion shouldn't really be considered. The second part that was mentioned was the face-to-face interaction between him and the informant and the first-hand knowledge that he has. I think that's very similar to what we see in confidential informant cases. And even there, where they're often dealing face-to-face, and they're often dealing with first-hand accounts of, I bought this drug off of this person at this particular place, that's not enough, because even in confidential informant cases, you need to have the reliability proven. You need to show reliability in order to consider any of their information. The other point I wanted to make that I didn't quite get to was about Gates and why Gates is so important. Gates marked, of course, the shift from the way courts were interpreting the Aguilar and Spinelli decisions of independently requiring this basis for knowledge proof and the reliability. And instead it moved to the totality of the circumstances. And the reason that it did that, the factual push behind that, was because of the massive amount of corroboration by police of getting this tip from an informant and then corroborating it and following them from Illinois to Florida and back, and going through all of this effort to making sure that the information provided by the informant was corroborated, that you knew that there was some reliability there. And in the last paragraph of Gates, they talk about what got them over the bar. Because remember, when Gates got to the Supreme Court, it had just failed in the Illinois Supreme Court. They found that neither prong had been met. Neither the basis for knowledge nor the reliability was shown. Last paragraph of Gates says that it was that corroboration that pushed it over the bar, that showed that fair probability of criminal activity. And here we don't have that. When we look at what we have here, we don't have that strong element to make up for the deficiencies of another. We only have these weak elements. We don't have anything to rely on other than an informant we can't trust, with no corroboration, with a basis for knowledge that's based entirely on him spinning a tale, and there's nothing to fall back on. It fails at every level. And because they don't have this corroboration, that leads into Leon, because I don't think it's objectively reasonable to rely on something that is this lacking. All of these cases, all of the cases cited by Appellee, even in Leon, all require corroboration. They all have this thing in common, where they corroborate this information. And where they don't, where they just take this informant's word, I don't think that's enough. I think that is objectively unreasonable, and there's not enough indicia of probable cause in this affidavit that any objectively reasonable police officer would rely on it.
Okay. Any questions? Okay, thank you very much for your argument.